Good day, viewers. You're welcome to another episode of Tommy Talks Legal. And today I'm going to be talking about your C of O is not different from any other title. But before I continue, I'd like you to subscribe to my YouTube channel, click on the like button and share generously with your audience. So as I was saying, why is your C of O not different from any other title? I've noticed that most of the times when buyers, ask for the title document of a property and they get this response, it has a C of O. They are elated. There's this kind of satisfaction that they get from hearing that the property they are interested in has a C of O, without knowing that there is no difference between the C of O and a contract of sale or a contract of sale of land agreement or an ordinary deed of assignment. Why am I saying so? Because a C of O can be fraudulently misrepresented. Because a C of O, even though it seems to be a perfect title, needs to be investigated. Until it is investigated and ascertained as a perfect and good title without any form of defects, then you can be satisfied as a prospective buyer to go ahead and purchase that property. But if you're going ahead to purchase that property with just the mind that, they said it has a C of O and they've given you that document and you go ahead and pay, there's a possibility that you are throwing your money into the well. So what are the things that you need to look out for to be sure that your certificate of occupancy, which is also known as C of O, is a good title? Number one, I would always say it every day, every time I will sing it as a creed. Ensure that you do your due diligence, because a contract of sale of land agreement could even be a better title than a certificate of occupancy. So what is a certificate of occupancy? A certificate of occupancy is that land title document issued to a person by the government showing ownership of a parcel of land or an expanse of land. That is what a certificate of title is. And most of the time, it is issued by the state government of that state where that property is. So how do you investigate? What are the things that you need to look out for, when you encounter or you come across a certificate of occupancy as the title to the land that you intend to buy? Investigate that title. Now, when a certificate of title is forged and you go ahead and pay, on the premise that, this is a certificate of title, you should know that you have just thrown your money away. Because if you do not investigate, you would not know that that certificate of occupancy that you have been given is fake, is forged, it was fraudulently obtained or fraudulently misrepresented to you. In that situation, when you pay for such land or you do not investigate, you have thrown your money away. Number two, why you need to investigate that certificate of occupancy is to find out if that certificate of occupancy has not been fraudulently obtained. Now, how can a certificate of occupancy be fraudulently obtained? When it is stolen. So you can have a scenario whereby a property is owned in common, or the property is owned in common, and a particular member of the family, is able to get hold of the title to that document, of the title to that document. When you do not investigate, you would not know that property, or that property does not belong to just one person. If you do not investigate the title, you would not be able to get the proper identity of the true owner. That is why whenever I'm doing a land transaction, I always ensure that whoever I am dealing with, we get the national means of identification to be able to properly ascertain that this is who we are dealing with. So you're not just going to present a certificate to us or any title to us and we just take it hook, line and sinker without knowing the identity of the person that we are transacting with. So even if you tell us that, I paid part payment of this for this property, you must show an evidence of you paying the part payment. I remember a scenario where we purchased, I wanted to purchase a property for my client, and we met this person, and the person passed on to us a deed of assignment, and said this deed of assignment was given to him by the original owner, that he has just only made part payments for the property, that it's about a few millions of naira for him to just pay up. And I said, okay, if that is the case, please, can we have an evidence of the part payment you made to show us that, okay, you even have the right to deal in this land? And this person, the seller, could not at that time, produce to us an evidence of payment, even as small as a receipt. Eventually, he had to take us to the original owner of the property. He was actually given that property to sell on behalf of the original owner. Help us look for buyers. So you have situations whereby people will commit their, land title documents to agents to sell on their behalf, with the mind that you as a buyer should do your proper due diligence before going ahead to make payments. So another scenario is where that certificate of occupancy or that land title document has been used to secure a loan either from an individual or a bank. Where thorough investigation or due diligence is not done, you would not know that there is already an adverse claim or an encumbrance on that title or on that document or on that property rather. So where you go ahead and pay, you have already brought, you've possibly thrown your money away, or it could even be a property that is owned in common and some sects agree to the sale whilst others don't agree to the sale. Where there is no proper investigation, the buyer has already bought for himself trouble. Another third scenario whereby a C of O could be a defective title or even a bad title is where the property is already a subject of litigation or there is an adverse interest. What do I mean? We could have situation whereby two people are issued certificate of occupancy for the same property. But where the buyer, the prospective buyer, does not do due diligence, this truth will not come out. Now you have to find out, when you're doing your investigation, you have to trace the history of that property to its first owner. When you're able to trace the property or trace the documents that are produced before you, is able to give you the history of that property to its first owner, and you have the necessary documents in place, then you can say that you have a good title. But where there is an adverse claim, or adverse interest by another third party, the first in time will become a priority before the court. Because of these situations are the reason why we always say that regardless of a certificate of title or a certificate of occupancy being presented to you as the title of a land that you have the intention to buy, do not jump into payment or accept proper investigation and due diligence has been done. Another scenario is where the certificate of occupancy is fraudulently obtained. This could happen where a member of the family of a property owned in common gets hold of the documents without, carrying other family members along as to the sale of the property. Now, if you as a prospective buyer go ahead to pay without properly investigating the title of that document or tracing the title or the history of that property, you will be throwing your money away. And I would always tell my clients, for every transaction you want to do, ascertain the identity of the person or persons you are dealing with. Now, where you do not ascertain the identity of the person you're dealing with, or you do not investigate the title to know the history of that property, you may be throwing your money away. Eventually, that C of O will be a bad title, because at the end of the day, when you have paid, you have already thrown your money away or bought yourself litigation. What other scenario could happen in this circumstance where that certificate of occupancy was used to secure a loan, either from an individual or from a bank? If thorough investigation is not done, you would not know as a prospective buyer that there is already an encumbrance on that title. These are the reasons why we always say that a C of O is not a good title until some investigations or due diligence has been done. Another scenario, or the last scenario I will be painting for you to my viewers, is where there is an adverse claim or that property is already a subject of litigation. What do I mean? What do we mean by adverse claim? Where there is a third party interest or an adversary on that property, or that property is already a subject of litigation. If you do not carry out the necessary investigations or due diligence, you would not know that that property is already a subject of litigation. You would have gone ahead to pay on the premise that, or on the satisfaction that, this property has a C of O. So we would always advise clients, or I personally advise clients, that whatever title that is presented before you, ensure that you trace the root of title. When I say trace the root of title, find out the history of that property to the first owner and ask of each documentation done from one buyer to the other, and ensure that you as a prospective buyer secure and perfect your title. If this video has been helpful enough for you, please once again subscribe to my YouTube channel, click on the like button, and share generously with your audience. For any comments, observations, or questions, kindly slide into my DM, as I will be there to answer you. Until I meet with you again in my next episode, stay good.